Okay. All right. Well, good morning, everyone. My name is Alyssa Fleming, and I'm a healthcare attorney in the Charleston office of Womble Bond Dickinson. Before we get started, I wanted to just go over a few housekeeping items. We are recording today's presentation. A copy of the recording will be available to all attendees following the presentation today. We encourage you to ask questions during the webinar. To ask a question, you can use the Q&A box that's located on the right side of your screen. Your questions can be typed at any time during the presentation, and we'll attempt to answer as many questions as we have time for. In order to receive CLE credit for today's webinar, each attendee will need to identify and submit 3 codes that'll be identified during the presentation. We will make sure to make it clear when a CLE code is being announced. So after the presentation, you can submit the codes. I guess during the presentation, on the right-hand side of your screen, you'll see a polling question appear. You should see question number 1 available now. To enter your state and bar number information, if you're requesting CLE credit, go ahead and submit that information now. When you hear a speaker announce CLE code word number 1 is X, you'll see a new polling question appear asking you to submit the code number 1, and you'll want to enter the code into the poll and click submit. You'll also follow the same process for codes 2 and 3. And if for some reason you have trouble with the polling, simply write the codes down on a piece of paper and you can manually submit them for credit to our event organizer, Abby Roberson, at abbie.roberson, REBERSON, at wbd-us.com. Okay, with that said, we'll go ahead and get started. As I mentioned, my name is Alyssa Fleming, and I'm a healthcare attorney here in the Charleston office of Womble Bond Dickinson. Joining me today are Catherine Wren and David Broughton. I'll let them go ahead and introduce themselves.
All right, my name is Catherine Wren, and I'm in Wombleville, South Carolina. I work with long-term care clients with litigation, but also with regulatory compliance issues. I help clients proactively prepare for surveys, making sure they're meeting the different requirements, and also help them post-survey, helping them with appeals, both on a state and a federal level.
Good morning, everyone. My name is David Broughton, and I'm a corporate attorney in Womble Bond Dickinson's Winston-Salem office, and I have the privilege of working with a number of senior living providers, helping them navigate a variety of issues. And we appreciate all of you joining us today and are looking forward to this webinar.
Right, thank you, Catherine and David. We'll go ahead and get started. So we wanted to host a webinar today to address some of the issues that the 3 of us have encountered as we've been helping clients navigate the challenges associated with COVID-19 and the evolving regulatory landscape that has followed. So my practice is very similar to Catherine's, and we'll go ahead and start by walking through some of the recent regulatory challenges, as well as some of the enforcement action that has followed. So just as sort of a background of the regulatory landscape, since the public health emergency was declared in late January, and the COVID outbreaks, in response to that PHE and the COVID outbreaks that occurred in many long-term care facilities throughout the country, the federal government, through the Department of Health and Human Services and the Center for Medicare and Medicaid Services, and the state regulatory bodies have issued extensive rulemaking and guidance to try to protect residents from the morbidity and mortality associated with COVID-19. The issues associated with COVID in the long-term care environment, as most of you are aware, first gained national attention following the COVID outbreak in the Life Care Center facility in Kirkland, Washington. That outbreak was followed by several other outbreaks in facilities in other parts of the country, particularly New York State. And then early this summer, we saw it happening in other areas of the country, specifically here in South Carolina. There were several as well. Since early March, CMS has engaged in extensive rulemaking to include a number of interim and final rules and initiatives to address infection control, heighten state survey requirements, and enhance enforcement penalties for infection control violations. The interim final rules and regulatory guidance have included extensive infection control measures, such as requirements for visitation and testing, which we'll touch on in just a minute. Although the CMS regulations are federal regulations that are applicable to skilled nursing facilities and nursing homes that accept Medicare and Medicaid funding, many states, and in fact, most states have adopted similar requirements for all long-term care facilities, including assisted living facilities and memory care units, even if they don't specifically accept Medicare and Medicaid funding. So it's important to understand that although the federal regulations may not apply to certain facilities or your facility, those regulations are being used as a guidepost by states in enforcing the state law regulations. So we recognize that many facilities are struggling with the challenge of complying with the regulations and keeping up with the ever-evolving regulations that seem to be unfolding, but also trying to mitigate the risk of non-compliance and at the same time providing quality care to residents and protecting them from risk. So with that said, we wanted to start by talking about two of the most recent issues that have been addressed at both the state and federal level concerning visitation and testing. Catherine, I'll go ahead and turn it over to you to talk about some of the visitation issues.
All right, well, I think at this point, everyone is aware of what the reasons are SNFs and assisted living. What used to be forbidden is now being required. Long-term care facilities have to now allow both indoor and outdoor visitation unless certain criteria are met, such as one or more COVID cases among staff or residents within the last 14 days. In fact, failure to facilitate visitation without an adequate reason can subject the facility to citations and enforcement actions. Luckily, CMS and the states have provided pretty detailed guidance for visitation. And at this point, it's advisable that all the guidance be included in the facility's internal policies and procedures. And obviously that the guidance be strictly followed. Because you can bet that the surveyors, when they come into the building, are going to be using that guidance about visitation as a checklist during the surveys. That guidance includes things like having outdoor as opposed to indoor visitation whenever possible, because outdoor visitation poses a lower risk of transmission. Also, indoor visitation, just as a reminder, depends on the positivity rate for the county. Per CMS guidelines, if the county positivity rate is greater than 10%, then indoor visitation in that case should only be allowed for the compassionate care visits. If the visit is indoors, you need to limit the visitor's movements within the facility. They shouldn't have free rein to go wherever they want to go. The visitors need to go directly to whatever the designated visitation area is. Don't allow them to wander throughout the facility as they please. Also, visits for residents who share a room really should not be conducted in the resident's room. Also, screening of anyone who enters the building or comes for outdoor visitation for signs and symptoms of COVID. And that includes the temperature checks and also asking questions about whether they have any signs or symptoms of COVID. And obviously, anyone that has or has a sign or a symptom of COVID should be denied entry. And importantly, the facilities need to be documenting all that screening. Right? They need to maintain a record of the screening because the surveyors are likely going to be asking for that documentation, especially if COVID cases do pop up. They're going to want to know what screening you were doing, and if you can't document it, it really didn't occur for purposes of the survey. Also, the guidance includes having a reasonable limit on the number of people visiting with any one resident at the same time. And with the holidays coming up, that might be more important than ever. Also, limiting the total number of visitors at the facility at one time. That needs to be in your policy. And face covering and masks for all visitors. Again, that needs to be in your policy. That needs to be enforced. And also, making sure that the face covering is covering both the mouth and the nose. Sounds easy, but I'm sure we've all seen people who have the nose outside of the mask, or they're wearing the mask as a chin strap. Again, social distancing. People need to be at least 6 feet apart during the visitations. And again, cleaning and disinfecting high touch surfaces is going to be really important. And resident and staff testing, which Alyssa is going to touch on in just a minute. But those are all part of the CMS guidance for visitation. And the latest CMS guidance tells the surveyor they need to be focusing on visitation during the surveys. So you know that's going to be one of the very things they're going to look at when they come into the facility. And the CMS guidance instructs the surveyors they should focus on 2 things. One, whether the facilities are actually adhering to their infection control practices. And 2, whether they are limiting visitation without a reasonable clinical and safety cause. That's what the surveyors are going to be looking for. And the best piece of advice we can offer is to not only make sure your facility is following that guidance, but to make sure that the guidance is in their policies and that your facility is documenting all of the efforts to comply with that guidance. And just as a reminder, at least in South Carolina, all long-term care facilities, SNFs and assisted living facilities are required to submit their weekly report to DHEC about visitation. The report has to tell DHEC whether the facilities are allowing visitation, and if they're not, explain why. And they have to report the number of visits of residents who had a visit during the last week. And DHEC is taking this seriously. The visitation report is due by Monday each week at 5 p.m. And there is a potential fine of $1,000 a day for not complying with that reporting requirement. And as of last week, according to DHEC's website, a lot of facilities had not submitted their reports on time, or they were not yet allowing visitation. So I know this is a struggle, but it's a huge focus for surveyors, and so it needs to be a huge focus for facilities as well. Now, Alyssa, I think you're going to tell us kind of a brief reminder about what the latest testing requirements are.
Sure. Yeah. Thanks, Catherine. So by now, everyone I'm sure is familiar with the federal and state rules for testing. CMS issued an interim final rule on August 26th that required testing for all residents and staff of Medicare, skilled nursing facilities, and Medicaid nursing homes. Many states have followed suit and are now requiring testing for all SNFs and assisted living facilities independent of visitation or as a condition to complying with the visitation rules that Catherine just discussed. For instance, in South Carolina is now requiring all facilities to comply with the CMS guidelines for testing residents and staff in conjunction with the state's recent guidelines for outdoor and indoor visitation. So some of the issues that we've run into with regard to testing have to do with staff and our residents refusing testing. And I'm sure you're aware that staff and residents have the right to refuse testing, but the question becomes what to do if and when they do refuse. So first things, facilities should have your policies and procedures that address testing, what to do if staff and residents refuse testing or are unable to be tested. As Catherine mentioned, on survey, they are going to look for written policies and procedures addressing these kinds of issues because this is going to be something that they're going to want to make sure that you're educating your staff about and educating them to make sure that they understand what to do in different circumstances. So managing the refusal to test with regard to employees and vendors can be handled, really in accordance with the guidelines and the facility's employment policies. How you manage staff may depend on the reason for the testing. For instance, if it's routine, outbreak, or testing as a result of a symptomatic resident or staff member. CMS tells us that the facilities have the right to and should restrict staff members who refuse testing from entering the building until the procedures, at least for outbreak testing, are completed or until the return to work criteria are met when the testing's done because of a staff member who has signs or symptoms of COVID. CMS also, in its guidance, states that facilities should ensure that residents with signs or symptoms of COVID who refuse testing are being placed on transmission-based precautions until the criteria for discontinuing those precautions are met. If a resident who's symptomatic refuses testing when an outbreak is performed, the facilities are instructed to be extremely vigilant through adherence to additional monitoring to ensure that the residents properly distanced or separated from other residents, that he or she is wearing a face covering, and that they're practicing effective hand hygiene until the criteria for testing are complete. Also, I would suggest that you try to facilitate good communication with family members so that family understands what's being done and why their loved one is being placed on precautions or why they're being separated from other residents. Those are things that are going to be important. And obviously, surveyors are going to be instructed to, or are being instructed to, evaluate for compliance with the testing requirements by asking for the facility's documentation of testing. And they're also going to be monitoring county positivity rates to evaluate whether testing is being conducted appropriately and timely. So you'll want to make sure that all of the testing that you're doing is well documented. You want to keep a log demonstrating when tests were performed, the county positivity rates for routine testing at any given time, the date and the time of any outbreak. And if a staff or resident refuses testing, the refusal should be appropriately documented in the resident record for residents and then personnel file for staff. Surveyors are going to want to understand whether facilities have counseled residents about the importance and the reasons for testing and any alternative testing sources if that's the concern or the reason for the refusal. So you'll want to instruct your staff to document those efforts because that's something that they're going to look for on survey. One other issue that we've run into is, and facilities have had concerns about, is the timely availability of test results and also the availability of test supplies. The government recognizes that there has been a shortage of testing supplies that's limited or prohibited appropriate testing in facilities. If that happens, facilities will want to document or show that documentation on survey that you contacted state and local health departments for assistance. And the same applies if the test results are not available within the required time frame. Some of the citations on survey, at the federal level, they're going to cite for failure to comply with testing requirements as non-compliance at the F866 level, and failures are subject to civil monetary penalties in accordance with the enhanced penalties that were announced by CMS in June. And obviously some factors will come into play, such as whether the non-compliance is widespread or pervasive, whether the facility has previous infection control deficiencies. I think there's naturally going to be a level of subjectiveness by surveyors in determining the scope of the violation and the CMP level to apply. So it's going to be important that if you have these issues, they are well documented in your documentation in the event that you decide that you want to appeal or challenge them on appeal. Enforcement action can also include directed plans of correction and root cause analysis. So it's a lot of risk there, and just a lot to take into consideration when you're walking through the different testing requirements. So with that said, I think that factors into the recommendation of having a COVID plan, which Catherine's going to discuss in more detail.
And before we jump into the COVID plan, just one more thing about testing. What we've seen in our line of work is what happens when you have a testing lab that's going to come to your facility and do testing, but they don't show up. You need to make sure you have a backup plan, because unfortunately things happen. Maybe the lab's running late that day, whatever the reason. If you don't have testing going on in a day when you're supposed to have testing, you might get a citation for it if you don't have a concrete backup plan. So whether that's another lab that's going to come in as a backup, or whether you're going to be able to do it internally with a nurse, you need to have some kind of plan. And like Alyssa was saying, one of the things that we really been recommending to clients is you need to have an actual COVID plan. Because one of the first things the surveyors have been asking for is, where's your plan? And what they mean by that is something in writing that is going to show all of your COVID related policies and procedures and documentation. And it would really be great if you had all that in a notebook all together. So when a surveyor does come in and say, hey, where's your plan? You can just hand them the notebook and make it a lot easier for them. And the COVID plan really should incorporate into that one notebook all those policies and procedures like the ones we've been talking about. It needs to have your visitation policies in it. It needs to have your policy about compassionate care visits. It needs to have testing policies like the ones Alyssa just talked about. It needs to have your policies about what to do when you do have a positive resident or a positive staff, including your roommate policy, your client. Also, social distancing policies, your PPE policies, infection control and cleaning policies, your staffing contingency plans, what to do, what is your concrete plan when you do have a staffing shortage, and things like your communal dining policies, your policies about indoor and group activities, when you have COVID in the facility. The COVID plan really will serve as a great checklist for facilities to make sure they're doing everything they need to be doing. But it also will show the surveyors that the facility is aware of what the CMS and state regulations are, and that it has taken the steps to address them and enforce them in the facility. If you don't have a written COVID plan, then alarm bells really might go off for the surveyors. So at this point, I just want to tell everyone that we do have our first CLE code. So if you're going to apply for CLE credit, you just need to put into the polling section on the right-hand side the first CLE code, which is STAR, STAR, STAR. That's your first code. And then Melissa, I think you're up next, right?
I think so, yeah. Thank you. So just to follow up, one thing that Catherine said about policies is just being mindful that, policies and the importance of reevaluating your policies with every new rule or guideline that's issued. This is very cumbersome, in my opinion, but many facilities adopted policies that at the beginning of the pandemic were absolutely reasonable. And as the guidance has changed and evolved, there's been an effort, such as increasing visitation and social interaction with residents. Some of those same policies may now be considered on survey as overly restrictive and violation of the residents' rights. So there is a risk with not keeping your policies current and reassessing, whether something that you implemented, 8 months ago is still reasonable in light of some of the newer guidance. So with that said, we're going to start focusing on some of the enforcement action and what we've seen on survey, and then some of the penalties that have followed from that. So, Catherine, what are you seeing surveyors focusing on when they're evaluating for compliance?
So in terms of the pandemic, COVID, surveyors, at least right now, tend to focus on facilities that have had COVID outbreak and death on residents. And as I mentioned earlier, one of the first things that I'm seeing or hearing that surveyors are asking for when they walk into the building is, let me see your COVID plan. And, for a while, a lot of facilities didn't realize that was a requirement, but surveyors really are looking at it as a requirement and as part of the new standard of care. So you need to make sure you do have all the latest guidance put into your written policies and procedures. Surveyors are also looking at whether the facilities not only have those procedures, but they're enforcing those policies and procedures. And I think at this point in time, 8 months into the pandemic, we're all tired of COVID. And I think we're all seeing a lot of COVID fatigue, especially when it comes to wearing masks and following all the different policies and procedures. Everyone's just tired, but we really need to make sure that everyone's still following the policies and procedures, because the surveyors are coming in and they're looking and observing staff to see whether the staff are washing their hands when they're supposed to be, whether they're wearing their PPE and they're wearing it in the appropriate way, whether the staff, are wearing the masks that are covering both their nose and mouth. Sounds simple, but I've seen citations where staff are not. They're looking at whether the staff are changing their PPE when they should, after treating a positive resident, etc. They're also interviewing the staff about their PPE. What training did they receive? Do they know when they're supposed to change their PPE? Do they know how to put their PPE on the right way? They're also looking at staffing, and they're really looking at that heavily, especially to see whether or not the minimum staffing requirements are being met on each shift. And I know that staffing is a huge challenge for everybody, but I've seen multiple citations already of failure to have sufficient minimum staffing on shifts. And if you are having issues with staffing, one of the things that the surveyors are going to look at is, what was your concrete plan to deal with that? Did you have a deal with a staffing agency? Did you reach out to the local health department about the issue? They're going to be asking those questions. It's simply not enough to say people didn't show up on shift, or we had some COVID positive staff that didn't make it that day. We're seeing citations for all those things and more. And what we're really seeing most of the citations come from are things like the PPE issues, failing to keep residents 6 feet apart, failing to or allowing positive residents to room with negative residents. Unfortunately, we're seeing a good bit of that, especially in the assisted living facilities. Failure to follow COVID policies or having unclear COVID policies has also been a citation issue. We've also seen citations for staff returning to work too soon after they've tested positive, and failure to take, or most likely failure to document, the screening of staff for COVID symptoms and their temperatures. And I know that it's a lot on staff to make sure to document everything, but again, if it's not documented, you can't prove that it happened. So that's kind of what we're seeing in terms of what citations are showing up. Alyssa?
Yeah, so in conjunction with the citations, since March of this year, CMS has issued more than 15 million in civil monetary penalties for infection control deficiencies. And a lot of the citations that Catherine just mentioned fall within the rules and the guidelines for infection control. So that's part of where the CMPs are coming from. This amount is actually 3 times the amount of CMPs that were issued over the same time frame in 2019. So that's huge. When they broke down the numbers, they said that 10 million of those fines just since March stemmed from infection control deficiencies, and approximately 5.5 million resulted from the failure to appropriately report COVID data such as infections and deaths. As of late August, there were 180 infection control violations at the immediate jeopardy level. And so just as a reminder, immediate jeopardy is a situation, represents a situation in which noncompliance has placed the health and safety of residents at risk for serious injury, serious harm, and or serious impairment or death. I think surveyors are going to take more of a strict approach when looking for and evaluating infection control issues because of the potential ramifications. And so I think they're going to be less hesitant to find violations at the immediate jeopardy level. The average CMP per facility was about $55,000. Other non-monetary penalties include and have included the discretionary denial of payment if you're a recipient of federal funding, and for new admissions with a 30 to 45 day period to demonstrate compliance with the infection control requirements depending on the level of the violation. And just as a reminder, the civil monetary penalties have been increased. So they now range from up to $5,000 per instance to $20,000 per instance violation. So they're not insignificant. Be mindful too that surveyors have the authority to place holds on new admissions. This can have a real significant impact on the census and the ability to accept new residents. And from a business perspective, facilities are already strained due to the pandemic, and placing a hold on new admissions really can cause substantial increase in financial strain. So there are business impacts as well. We've been seeing assisted living facilities that have failed to implement written infection control policies that are consistent with the CDC guidelines, or that they're not updating them to continually comply with the CDC guidelines. And those are being cited as a violation of infection prevention requirements and declaration of resident rights. For instance, in North Carolina, this is being cited at an unabated level B violation, with a per instance fine of between $12,000 and $13,000, and those are just for not having written policies. So some of the other states, and New York's been receiving a lot of attention, so there's been a lot of news coming out of there. But there was recently in New York facility and a couple facilities in New York State that were fined for the failure to follow infection control guidelines. And this included things like Catherine said about the PPE, failing to wear gloves while providing COVID care to residents, and housing, failing to separate COVID positive from COVID negative residents. And those fines have been, up to a $50,000 per violation amount. So not insignificant. And I think that the states are going to look to other states when trying to determine the level of the violation, and then also the appropriate monetary penalty amount. So the precedent's out there. And I think that, the potential ramifications from the issuance of civil monetary penalties and citations on survey can have significant financial and reputational impacts, and can be devastating. They can have negative implications just from a marketing and public relations perspective. The data is being published by states, so the number of COVID deaths and infections per facility is out there. This is also being published for those of you who receive federal funding on the CMS Nursing Home Compare website. States are also publishing information about facility violations, fine amounts. It's all readily available. And there are also a lot of, not a lot, I'll say several news articles recently in the local papers discussing complaints by family members. So complaints made by family members to regulatory bodies, and they are gaining a lot of attention. And the family members are really sort of the first ones to speak out, I think, when they see things happening, particularly if a facility hasn't been surveyed yet. So we talked a little bit at the beginning about the Life Care Center of Kirkland case, and that decision was actually appealed all the way to the Administrative Law Court in Washington State. And since we were talking about enforcement action, we want to talk a little bit about that case, and Catherine's going to talk about that. What do you think? I guess, Catherine, what are your thoughts on that decision, and whether facilities can rely on it, since at the appellate level, Life Care Center did receive a favorable outcome? So,
before I get into that, I just wanted to let everyone know the ELE code is, so if anyone is applying for credit, you'll need to put into the polling section on the right-hand side of the screen the second code, which is GREY, GREY. I was talking about what happened with Kirkland, and Kirkland, as we all know, or probably remember, is the Washington State SNF that first made headlines in the United States as one of the first SNFs that was really hard hit by COVID. And following the outbreak, Kirkland was hit with state citations and with CMS citations. And those citations were based on the facility's failure to secure adequate doctor and staff coverage, failure to provide residents required care, which I think is just a big catch-all for anything COVID related. Also, failure to have contingency planning for when the services, staffing, and interventions needed were beyond the facility's capability at the time. And also the general failure to contain outbreak. So that's what the citations are based on. And the enforcement action included the state coming in and halting admissions at the facility. And CMS also held the facility in immediate jeopardy and imposed a CMP of over $600,000. Kirkland appealed both the state and CMS enforcement actions. The CMS appeal is still pending, so we don't know how that's going to turn out, but the state appeal has been heard and the administrative law judge overturned the state's ban on admissions at the facility. And initially, there was a lot of excitement that Kirkland won its state appeal and had the admissions ban overturned, especially because we are seeing admissions bans as a popular form of enforcement action right now with the states. But unfortunately, once you read the opinion, it's really fairly limited. It's fairly limited because it's based on the fact that Kirkland was one of the very first facilities to be hit by COVID in February and early March. And I remember that because my family was actually in San Francisco at the time, thinking that COVID was not going to be an issue in the United States and we were fine. But Kirkland was being hit at that point in time. And that was before CMS issued any kind of detailed guidance for facilities about COVID, before the COVID testing was readily available. And as a result, Kirkland had a really great, we didn't know defense, and the ALJ agreed with them. The ALJ found that at the time, again, February and early March, there was no reason for the facility to think that the residents' symptoms they were seeing were anything different from what they'd seen in the past with regard to respiratory illnesses, pneumonia, et cetera, because no one really knew what to think about COVID and what kind of signs and symptoms to look for. And the ALJ also found that there was no evidence at the time that the facility should have recognized there was a COVID outbreak any sooner than it did. And there was no evidence of what the facility could or should have done differently in regard to COVID at that time. So great outcome for Kirkland, but as we all know, the landscape has changed dramatically since February and early March. Now you essentially have to be living under a rock to know about these COVID signs and symptoms and about all the different regulations that have come down from CMS and from the state. So in other words, it's really hard at this point for facilities to claim the we didn't know defense. Now I've seen facilities still trying to claim that, or just the we didn't know what to do defense. That's really not going to work that much anymore. And I'm not sure we're going to see other decisions like Kirkland coming down in regard to any recent citations that are coming out, because everyone knows about COVID now, and you have the detailed CMS and state guidance that's telling you what you should do and what you should be looking out for, and what to do when you do have a COVID outbreak. So initial excitement about the decision, I'm just not sure it's going to have long-term effect on citations beyond that initial phase of COVID.
Yeah. And just quickly, we want to touch on just the fact that we know that the COVID lawsuits alleging negligence for failure to follow infection control guidelines are coming, and just a negative survey can certainly have significant implications in litigation. We anticipate that plaintiffs' lawyers are going to rely heavily on survey results and monetary fines as a basis for alleging improving negligence, gross negligence, and recklessness. In some states, such as North Carolina, Virginia, have enacted statutes limiting liability or creating immunity arising from decisions, acts, or omissions related to the care of COVID-19 residents. But plaintiffs' lawyers are likely going to try try to rely on those survey results to try to circumvent the statutes. And as just a reminder, those statutes are defenses to liability, and the facilities have the burden to prove why they have immunity or why their liability is limited. So it doesn't preclude a plaintiff from bringing a lawsuit. It's merely a defense to liability. So I think we're going to see those lawsuits. It's just a matter of time. With that said, I'd like to go ahead and turn this over to David for a little while. He's going to talk about some of the risk management strategies from a corporate governance standpoint related to COVID. So,
great. Thanks, Alyssa. So yes, as Alyssa said, I'm going to just try to step back and give a little bit broader view from a corporate perspective of some things that you ought to be doing or considering, which might help mitigate the risk to your organizations and to your directors and officers. Much of this may sound like I may be preaching to the choir, or I'm just reinforcing and giving gentle reminders of what I'm sure most all of you are currently doing, but I don't think it ever hurts to get those gentle reminders every now and then. And I think some of you may have heard some of these from me in the past, so maybe duplicative, but again, never hurts to hear. I think one of the first things to mention is that, and just to reemphasize, is the importance of the board and the management maintaining very close communications with one another, particularly as things continue to move so quickly and change so quickly. If you haven't already this year or during this pandemic reviewed your corporate documents, being your articles of incorporation or organization, your bylaws or operating agreement, or your other committee charters and other internal corporate governance documents, I think this is a good time, because you have learned, certainly have learned lots of lessons, I'm sure, over the last 6 to 8 months that you probably did not expect to encounter prior to the pandemic. And so those lessons will, I think, are likely to help inform you as to your current structure, your current structure of your organization, and maybe how you should contemplate changing that structure or changing certain components of it, which might help enhance that communication and working in close partnership between the board and the management. So it's not enough just to review and potentially implement changes to your corporate governance documents, but obviously I want to just emphasize the importance of following those documents. It's not enough just to have those documents and put them on the shelf, but you really need to make sure that you're following those internal corporate governance documents. As Alyssa and Catherine have talked about with regard to the pandemic, the importance of reviewing and adopting and implementing and consistently enforcing policies and procedures. And again, I would say not just with the those policies and procedures that are pandemic related, but other policies and procedures, again, based on your experience over the last 6 to 8 months, there may be changes or things that need to be, you think that should be implemented that would make the organization more effective and help protect against certain risks. You want to make sure that your entities are not thinly capitalized and that you have adequate financial resources. You want to make sure that you're taking all reasonable steps to protect the corporation's assets and to provide proper financial oversight. And then, obviously, as we've been touching on during this webinar, ensuring legal compliance and ethical integrity in everything that you're doing. Again, as I mentioned, during this pandemic, things have moved and do continue to move quickly, and there is new and different guidance coming out weekly, if not daily sometimes. So it's hard to keep up, but it is important that you look at your structure, and it may be that if you haven't already implemented a committee or committees to help oversee and to provide oversight for particularly the pandemic related issues that you're dealing with, whether that's through an executive committee or a specifically designated committee, that way you can move, I think, more quickly and nimbly between board meetings. Now, that doesn't mean that you are just going to act by committee alone. You need to make sure that the board is kept well informed, and there may be particular decisions that would really be sort of outside the scope of the authority of the committee, or even if arguably it's within the scope, it may be best to actually go before the full board. And so that's kind of a judgment call that just will have to be made. But I think having that structure in place so that you can move quickly and adapt quickly is important. Just want to remind you all that the importance of being aware and fulfilling directors and officers' fiduciary duties. You all know these and have heard these before, but particularly the duty of care and the duty of loyalty. I'd say in particular in the areas that we've been talking about today, the duty of care. And just as a reminder, that requires that directors and officers be informed, and that's, I'll say that again, be informed and discharge their duties in good faith with the care a person in a like position would deem reasonably appropriate under similar circumstances, and in a manner believed to be in the best interest of the corporation. So it's, you got to stay informed, you've got to act in good faith, you've got to act reasonably as others would in a similar situation, and you need to act in the best interest of the corporation or the organization. Generally speaking, directors and officers will, courts will defer to directors and officers if they take those actions. It's sort of the business judgment rule, and usually courts will defer. But again, it's important to be informed, to act in good faith, to act reasonably under the similar circumstances and in the best interest of the corporation. And it will not be enough just to point to COVID, or whether it's to a specific circumstance or point to the pandemic generally, but you're really going to have to follow that fiduciary duty. Obviously the duty of loyalty is another. And there, I think, when we think of the duty of loyalty to the corporation or the entity, we think about things like avoiding conflicts of interest, corporate opportunities, and confidentiality. And I think for the issues and the subject matter we've been talking about, confidentiality and conflicts of interest, I think, are two particular areas just to be mindful of. The other area I just want to touch on briefly is, if you haven't in the last 6 or 8 months reviewed your insurance policies, this would be a great time to do that, to make sure that they are all current, that they're all that you have adequate protection for the corporate risks, to make sure that you have D&O insurance that is in place with adequate coverage, director and officer insurance. And I also think it's a good idea to check with your insurance carrier, your insurance broker, to see if they have any specific guidance that they would provide in terms of either coverage or issues, particularly as it pertains to the pandemic and COVID. Always remember that if you receive a claim or a threatened claim by, whether it's a resident, a resident's family, another third party, you want to make sure that you put your insurance carrier on notice promptly, and I would say immediately, as well as consult with your legal counsel. You don't want to delay in doing that. And I think it's even better to take sometimes communities or organizations might have questions about whether they should or shouldn't, and usually, in our experience, the answer is going to be, well, you should, but go ahead and just put them on notice. Couple of other kind of corporate actions that would recommend doing if you haven't recently as well would be to take a look at your residence and care agreements, and to look at basically kind of a wholesale review of them, but they're kind of a few specific things to be mindful of. It's unlikely that you'll be able to amend those agreements for all of your residents. I guess it will just depend community to community, but in our experience, it's hard to go back and amend for communities that often have substantial numbers of residents. But you want to make sure, again, that the lessons you've learned and the things that you've experienced over the last 6 or 8 months do get reflected and get incorporated in your residency agreement on at least a go-forward basis, even if you can't amend it. And so a couple of things in particular to be mindful of would be to make sure that there is, excuse me, a provision that allows you to implement policies and procedures, and it makes the residents have to abide by those policies and procedures, and then that those policies and procedures are subject to change. You want to make sure to see if there is what we refer to as a force majeure or an act of God type provision, which might help communities with particularly the forgiveness where there may be interruption of services to residents that would be beyond the reasonable control of the community. And this may help a community provide a response or a defense for having to curtail certain services. And in our experience, it's unlikely, since I don't think a lot of people are sort of anticipating pandemics, rightly or wrongly, but it's unlikely that if you have a force majeure provision that it probably does not speak specifically to pandemics. But I do think it is a good idea to review those and to to work with your council to incorporate language that would address pandemics or epidemics generally, and might even specifically address COVID. And then, I guess the other thing I would just mention about the residence and services agreement is that each community is going to have its own appetite about how they're going to enforce those agreements. Obviously termination is certainly one remedy, but I think each community, and we've had to work with different communities about steps that they may take with regard to enforcing certain provisions within their agreement. And finally, I think if you haven't reviewed your other corporate agreements in some time, it's a good idea to go and take a look at your other third-party corporate agreements, particularly where you think there may be risk for your not being able to fulfill obligations under those agreements. You're going to be far better off if you can take a proactive approach in trying to remedy that situation rather than finding yourself in actual default and then having to sort of claw your way out of that default, as opposed to maybe taking more proactive steps to head it off before it becomes a bigger issue. So with that, I know we're running short on time now, but we'll turn it back to Alyssa, but thank you.
Sure. Thank you, David. I'll let Catherine go ahead and announce the third CLE code.
It is Chicago. The third CLE code is Chicago.
Well, thanks, everyone. We actually had some good tips to share with everyone, but I think we're running short on time, so we'll send a follow-up email alert with those follow-up points following today's webinar, and we're happy to answer any questions that anyone has in the next few minutes. So again, thank you so much for attending, and if you have any questions, go ahead and send them on.
One of the questions that we had was, I think, something that David was talking about. David, do you recommend that facilities look at rewriting their force majeure provisions if they don't specifically address COVID or a pandemic?
Yes, Catherine. I mean, I do think it's a good idea to take a look at it, and if that's not addressed as one of the items that, sort of the quote unquote act of God items, I do think that would be a good idea on a go forward basis. I think you have to be careful that that communities, if you're implementing that into your force majeure, that the force majeure is a one-way force majeure that allows the community to keep from, or sort of an excuse, if you will, for not being able to provide services due to those acts of God. But you don't want it to cut the other way and have residents be able to not make payments or have to abide by certain policies and procedures because of the force majeure. So you just have to be careful that it's drafted in a way that is advantageous to the community and not detrimental. Thanks.
And one of the other questions was, maybe this is meant for Alyssa to handle, but have you started seeing a lot of COVID-related lawsuits being filed yet?
Right. Not really. We've seen maybe a handful, but it's very early. We have to remember that there's a 3-year statute of limitations generally, and 2 for governmental facilities in some states. And so we are pretty early on with the potential for litigation. I think you're going to see those kind of cases mature over the next year or so as plaintiffs' lawyers try to develop their theories of liability, learn more about some of the citations and deficiencies on survey. Just as we've been navigating all of the guidance and the guidelines, they have too. And I think the fact that you've seen complaints generated from family members to some of the regulatory agencies demonstrates that they're also likely going to seek counsel at some point. And as we know, there are a number of lawyers that are pretty hungry for some of these cases. And I think too that, like I said, the statutes in some states that have been enacted, while they can be helpful, they're really just a defense to liability, and they're not going to preclude the lawsuit from being brought. So, yeah. And I think, Catherine, I think we have one more question, and it has to do with staffing. You mentioned during your discussion issues with staffing. Have you any specific recommendations about what communities and facilities can do if there are staffing shortages?
So what I've seen actually recommended from the surveyor's standpoint about staffing is that there are recommendations that staffing is for this industry, but they're recommending that some of these I wouldn't necessarily do, but this is coming from the surveyors. They're recommending that if you do have a COVID wing and you have a staffing issue, maybe you can consider having caregivers that are positive but asymptomatic come in and work on that COVID wing. They're also recommending that you have a concrete plan with a temporary staffing agency. You already have a contract with them, or you at least have an opportunity to reach out to them and get their help. They're also recommending that contact local hospitals for temporary staffing support. I know there are a lot of furloughs at hospitals during the initial phase of this, so there's always a possibility they can help you with staffing. And if all those options have been exhausted, I touched on this earlier, but they're recommending that you need to reach out to your local health department and request help, request emergency staff from the state, and again, document all of those efforts. So if you do end up having an issue with minimum staffing one day, you at least have documented all the efforts that you went through, all the reasonable efforts you went through to try to find staff.
Okay, well, thank you. It looks like it's a little after 2, and we just want to thank all of our attendees for attending today and letting us be with you. And if you have any questions, feel free to reach out to us directly. We'd be happy to help.
Thanks, guys.
All right, thank you.
Thank you. Okay.